All right, this video is about whether you should hire an attorney for the preliminary hearing only or for the entire case, which includes the preliminary hearing and the trial if necessary. If you or a loved one is charged with a felony, this question comes up a lot because you call around asking for attorneys, and the attorney's office is typically going to be, do you want an attorney just for the preliminary hearing, through the preliminary hearing, or for the trial as well? And those are going to be two different prices because up to the preliminary hearing is usually hiring an attorney to settle the case or conduct the preliminary hearing, which usually is less than a day. And it's a short hearing, relatively short. It's before the judge only, and it's preliminary. All the judge has to find is that there's probable cause that you committed the crime, hold you to answer, and take you up to a trial court. A trial, on the other hand, takes intensive preparation and a lot of time, and so to hire an attorney from the start to the finish is going to be a higher price than just for the preliminary hearing. My advice, generally speaking, is that if you can afford it, you hire an attorney from the start to the finish, so you know that you have coverage, you can sleep good at night, and you can, if you don't like the deal that's being offered to you or the disposition, you have the choice to take it to trial. Now, for people who are facing more financial constraints, maybe they can't afford an attorney up through the trial or they need time to gather the money, there's certain circumstances where I would suggest that you can hire an attorney just for the preliminary hearing. Number one is if it's not a super serious felony. For example, there's no violence. Felonies like commercial burglary. You go into a store with no violence and commit a theft, or you're being charged with felony vandalism, no violence there. Those cases are more likely to settle before the preliminary hearing because there's no violence. Generally speaking, the more serious a case is, the less likely it's going to settle at the time or before the preliminary hearing. Number two, if you are willing to settle your case, then you could probably hire an attorney for the preliminary hearing because it may or may not settle. On the other hand, if you are committed to not having a conviction on your record and you want to fight it no matter what, you should certainly hire an attorney for the entire case, including the trial, because a lot of times the DA is not going to offer a diversion or a dismissal unless you take it to the brink of trial and you push it beyond the preliminary hearing. Number three, you could hire an attorney for a preliminary hearing if you're not sure about the attorney and you want to kind of test them out and see if you work well with them. And then so you hire them for the preliminary hearing and you could rehire them for trial. Now, the downside to that is that a lot of times, once you're past the preliminary hearing, an attorney, might, let's say, for example, say $15,000 for the whole case and $5,000 for the preliminary hearing. But once you're past the preliminary hearing, that attorney could up their price to, let's say, $15,000 for the part past the preliminary hearing, the trial, which would inflate your price overall to $20,000. And a lot of other attorneys don't like to take cases if they're not in from the beginning because, once it gets past the preliminary hearing, it gets a lot more serious and there's a lot greater probability that it's going to go to trial, which means that there's a lot more work involved. So the general advice is hire the attorney for the trial if you can.